Hi, this is Lee from the Law School Toolbox. Welcome back. This episode is part 1 of a 4-part series called Legal Writing Makeover. In this complete series, we will take a poorly written piece of legal writing and transform it into Legal Writing A+, one section of IRAC at a time. We will also give you some general legal writing tips that you can use to self-edit your legal writing. But before we jump in to our makeover, let's set up the situation. You are responding to a short answer question on an exam that asks whether there is an enforceable contract against the buyer. The facts indicate that the buyer and seller agreed via phone that the seller would sell the buyer a boat for $400,000. However, after this phone conversation, the buyer sent a signed letter to the seller stating, "I have run into some financial difficulty and will not be able to honor our agreement to buy your boat for $400,000. The seller now wishes to enforce the contract against the buyer. Again, the prompt asks, is there an enforceable contract against the buyer for the sale of the boat? Let's take a look at a response to this question that could use a makeover. The response states, the issue is whether there is a contract for the sale of the boat. The formation of a contract requires a mutual assent, which involves both a valid offer and acceptance consideration or a bargain for exchange involved, and a lack of any defenses to the formation of said contract. The UCC Article 2 is the presiding contract law concerning any sale of movable goods. The UCC likewise has a statute of frauds provision which requires that a contract concerning movable goods of over $500 be written on paper in writing. Here, the buyer and the seller had a conversation on May 1st where they agreed to the sale of the boat for $400,000 and agreed that the seller would deliver the boat to the buyer's house on May 4th, which the buyer would then pay the purchase price. This agreement indicates a mutual assent and a consideration and has no defenses to formation. However, because the boat is a movable good over $500, therefore the statute of fraud requires the contract be in a writing. The buyer signed a letter and mailed it to the seller indicating he did not want to buy the boat. This letter satisfies the statute of frauds requirement and would be an enforceable contract against the buyer. Whew. Okay, let's start with what is working in this answer. The author generally used IRAC to structure the answer. The author also stayed mostly on topic and eventually answered the exact question in the prompt. Unfortunately, it is a bit of a hole to get to that answer. So let's break this down using IRAC and make it easier to immediately spot that this author knows the answer to the question. Let's start with the I in IRAC or issue statement. The answer states, the issue is whether there is a contract for the sale of the boat. Well, kind of. Remember specifically what the prompt asks. Is there an enforceable contract against the buyer for the sale of the boat? Whether the question asks about enforcing the contract against the buyer or the seller may be an important detail in a question that raises the statute of frauds. This brings us to our first general legal writing tip. When you are writing your issue statement, make sure to capture all details that are relevant to your analysis. Here, we are only analyzing the enforceability of the contract against the buyer, and we must make sure to include that detail as part of our issue statement. For example, we could amend this issue statement to say, the issue is whether there is an enforceable contract against the buyer for the sale of the boat. That issue statement is a perfectly accurate rewrite of the question prompt. But is there a way to make it better? Absolutely. Here is the bad news. If you are writing a law school exam or a bar exam answer, the grader is unlikely to award points for accurately rewriting the question. So rather than wasting time writing a sentence that does not earn points, let's talk about how to earn points, or at the very least, earn the trust of your grader with your issue statement. This brings us to our second legal writing tip. Use your issue statement to identify the specific issues that you must determine to answer the question prompt. If you must determine more than one issue, break each issue into individual mini IRAC sections. We will talk more about how to use mini IRAC in part 2 of this Legal Writing Makeover series. But let's identify the major issue, or biggest potential problem with this contract. It is subject to the statute of frauds. So we must determine whether we have a writing that satisfies the statute of frauds for the purposes of enforcing the contract against the buyer. Given the buyer's follow-up letter to the seller, you could write your issue statement as follows. The issue is whether the buyer's letter to the seller is a sufficient writing to satisfy the statute of frauds and enforce the contract against the buyer. Again, the simpler issue statement rewriting the prompt is not wrong, and it is a fine issue statement to which to resort if you are pressed for time. But you will likely earn more points and make a better impression with your grader by writing an issue statement that identifies the specific major issue raised by the prompt. That wraps up part 1 of our Legal Writing Makeover series, How to Fix Your Issue Statement. We hope that this episode helps you understand how to earn points on an exam by writing specific issue statements. In part 2 of our Legal Writing Makeover, we will continue working through the answer given above, tackling our rule statement. Rule statements are extremely important because they impact the rest of your IRAC. So make sure to look out for part 2 of our Legal Writing Makeover series, How to Fix Your Rule Statement. Thanks for watching, and please like, subscribe, and leave us a comment if you have any questions or suggestions of what you'd like us to cover.